यार में 5/308/25 वकील श्री डी.पी. पंड्या सेक्शन 408/18 बड़ेलाल वकील श्री एस.बी. प्रजापति सेक्शन 3/21 शकुंतलाबेन वकील श्री एम. राजपूत फरियाद लेना हाजिर છે ફરિયાદ લેનાર હાજર છે વિજય રાઠોડ સેશન્સ 52/21 કિશન બાવરી એમાંથી નંબર 2 ની એક્ઝામ્પશન આપે છે પંચ હાજર છે
એક હાજર છે
હા સર એક હાજર છે એકને અગાઉ તપાસેલો છે ઓપન છે
કિરણ તો કિશન છે
કિશન ની એક્ઝામ્પશન છે
પંચ આવ્યા છે
હા સર
લઈ લેશો
સેશન્સ 5/22 રિયાઝ ખાન પઠાણ એકની એક્ઝામ્પશન
કોણ આવ્યું છે
રિયાઝ ખાન આવે છે 7 સાક્ષી તપાસેલા બીએસ પટેલ
રિપોર્ટ લઈ લઈએ રિપોર્ટ આપશો 4/8
ઉધરની અરજી સેશન 60 હા કીધું સેશન 60/22 ભાવેશભાઈ પરમાર મનીષ ચૌહાણ वकील श्री एच.एस. परमार वकील श्री यू.ए. मंसूरी सर नंबर 1 નું વોરંટ ચાલે છે
એમાં એવો શેરો આવ્યો હાલ સાબરમતી સેન્ટ્રલ જેલમાં
બીજા કામમાં છે
હા સર તપાસ
2 નંબર પર
वकील श्री यू.ए. मंसूरी
સમસ્યા છે
ના સર
પછી
सेशंस 251/22 अहमद सामनी वकील श्री एम.एम. बुखारी તે હાજર છે સર અને એમાં પોલીસ સાહેબ હાજર છે મોહમ્મદ સાહિદ સબીર
આવે છે
હા સર અને બીજા આવવાના છે પોલીસ સબ ઇન્સ્પેક્ટર બીએસ રબારી અવેલેબલ વોરંટ હતા બંને વકીલને બોલાવી લેજો અહમદભાઈ વકીલને બોલાવી લેજો બીએસ પટેલ सेशंस 138/23 सर आप भूलથી ખત થઈ ગયું જો 59 ની કામ છે દાવા 59 કરી
138
હા સર તબરેજ ખાન અલ્તાફ લતીફ મિયા લતીફ મિયા.
લતીફ મિયા.
સર 19 આપી હશે ને. સેશન્સ 475/23.
સ્વદેશી સેન્ટ્રલ જેલ
વકીશ્રી કેસ તમારી છે.
કે તમારી
સ્વદેશી
સ્વદેશી બાકી આવે.
સર એમાં ઈજા પામનારને કર્યો છે સમન્સ બજેલો છે. દિલીપસિંહ ચૌહાણ
દિલીપ ચૌહાણ.
બજેલું છે સમન્સ પણ હજુ હાજર નથી. રાજુ
બીજો અમારો
દિનેશભાઈ સેશન્સ 600/23. કેસ તમારી છે. સાહિદ છે કોઈ આરોપી નથી. સાહિદ અચ્છા એમાંય બોલવાલા વકીશ્રી એમાંય બોલવાલા. સાહિદ અરબ 413/24.
રફીકભાઈ અરબ.
અરજી આપું છું.
યાસીન ખાન જબર ખાન પઠાણ.
સર યાસીન ખાન હાજર છે.
યાસીન ખાન પઠાણ ભાવેશ પટેલ
એ પણ હાજર. સર આમાં આઈઓને કરેલા છે આર કે વાણિયા.
બીજા કોઈ પત્રી
હા સર આઈઓને કરેલા છે 4 માં. Yes, madam.
કોમન આવી
આયુ આવે છે.
એબીપીએસ પટેલ.
સમન્સ બજેલો છે.
તર્ક અધિકારી આર કે વાણિયા
દત્તા અધિકારી આ
મુદતની મોકલાવશે છે.
નથી આવે આ
ભાવેશભાઈ આઈઓ છે આર કે વાણિયા. બિરજુભાઈ બોલાવજો.
બીજુભાઈ
ના આ નથી આર કે વાણિયા નથી. વિજય રાઠોડ ને મોહમ્મદ સાહિદ છે.
વિજયસાઈ આર કે વાણિયા
ક્યાં છે આ ભાઈ?
રિપોર્ટ મોકલે એવો કોણ આવે કોણ દીકરો તો આવે.
ઓકે. રિપોર્ટ મોકલ્યો છે.
હા રિપોર્ટ
તપાસ કરો રેલવે કોન્સ્ટિટ્યુશન બોલો
સેશન્સ 998/23. સન્ની ગોહિલ વકીલશ્રી વીડી મસિયાવા.
બાકી બીજી બસ ક્યાં
સર આમાં શરૂ કરવા માટે છે સમન્સ નથી કરેલ.
કરવાનું છે.
હા હવે કરવાનો છે.
ડોક્ટર ને કર નાખી.
હા સર.
પીએમ ડોક્ટર કર.
હા
એક નો
સન્નીભાઈ 1 સપ્ટેમ્બર 1/9. હા સેશન્સ 3/24. વકીલશ્રી સીકે શાહ
બાકી બીજી તો
આરોપી યુટીપી 24 પણ હાજર છે. એક સાહેબ હાજર છે.
સાહેબ છે.
હા હાજર છે.
બીજા.
સેશન્સ 507/25. આરોપી યુટીપી છે સર રજૂ કરે છે એવું કીધું છે. તુષાર કોસ્ટી સેન્ટ્રલ જેલ. તુષાર કોસ્ટી
આજે છે
સર આમાં એક ફરિયાદ પક્ષે એક વકીલ હાજર છે. ટીએચ મહારાજા અમે શું મારા સિનિયર છે સર. એક સર એક કલમ ઉમેરાની અરજી આપેલી છે હમણાં હિયરિંગ માટે છે.
તેમાં
507/25 સર. મુદ્દામાલના યાદી કરેલી છે.
કલમ ઉમેરને કોને અરજી આપી?
સર આ ફરિયાદ ટીએચ મહારાજા વકીલ હાજર થયેલા છે.
તાર ફ્રેમ થઈ ગયું છે એમાં?
હા સર થઈ ગયું.
તો 7 લાગે છે એમ છે
507 માં
એક્ઝિબિટ સાથે
એટલે આ 326 લગાવ્યું છે. 326 છે કે શું છે? 311 છે. ફર્ધર ઇન્વેસ્ટિગેશન બી કરો. વધુ તપાસને ચાર્જ ઉમેરો કલમ ઉમેરો કરશે. તમે સાંભળે તો
બાકી છે.
તો જવાબ હા જોઈ લો કોપી આપો.
ઉપરી ખાંડ નથી
પછી જોવાની નેક્સ્ટ
1/21 ભદ્રુજામાં
આ રૂપિયા આવે છે પૂરી થઈ ગઈ છે બધી પુરાવો એડોપ્ટ કરેલો છે તમે છો મિસ પટેલ તમારે કઈ કહેવાનું છે તમારે કઈ કહેવાનું છે
શોર્ટમાં સાહેબ કહી દઉં આમ તો સાહેબ
લેખિત છે
જજમેન્ટ છે હા લેખિત હું આપી દઉં છું તૈયાર જ છે પણ થોડી ટાઈપમાં ગઈ છે
કઈ વાંધો નહીં, આપી દઈશ. હા બપોર રાખ
હા બપોર હું આપી દઉં
3 વાગે
હા 3 વાગે
3 o'clock રાખી
3 વાગે
સ્પેશિયલ પીટી છે એમની કાપડિયા
NI 1/22 1/23 2/23 4/24
ચાલતો ઓકે
1/22
Vakishree M. Ustad, Vakishree ID Pathan, Vakishree J.R.Rawal, Vakishree Anna Lodha, Vakishree Unit Sir આવવાનો છે સાથે એવું જાણ કરી છે
બધા યુટીપી છે કે બેલ આઉટ
સર છે બેલ આઉટ છે એમાં એક્ઝમ્પશન આવી છે
ગોવિંદરાજ છે બેલ આઉટ
હા એમની એક્ઝમ્પશન આવી છે
પછી બીજા ક્યાં
બીજા સરે 1/23
1/23 માં 5 નામ 10 છે
મુજાહિદ
એ છે બધા છે અત્યારે.
એ બધા અંદર છે
મુજાહિદ યુટીપી છે
જી સર
નાખતું મુજાહિદ સિનવાડી સન ઓફ લઝીર ખાન
અચ્છા યુટીપી છે સર
4/22
પાછી
યુટીપી છે એમાં બધા
4/22 માં બધા યુટીપી
લખ્યું નથી બ્રેકેટમાં એટલે જસવીરસિંહ
જસમીતસિંહ એ UTP એ પાકા માની છે
બધા યુટીપી છે
જી સર
બીસી માં સર પ્રેઝન્ટ બીજા કયા બેલ આઉટ
1/23 માં 5 નંબર છે ને
એ જાણે
જસમીત એ જામીન મુખ્ય એની એક્ઝામ છે જસમીત
પછી બીજું કોણ છે
એમાં 4 નંબર ઈસ્વીટર છે પાણીપત જેલમાં છે એ આવે છે.
પછી કોણ છે 5 જણા
પછી
4/24 માં છે સર પાછળ છે 10 11 12 13
4/24
10 11 12 ને 13
ઈરલાલ અભય પ્રતાપ ગગનદીપ અને
એક્ઝામ્પશન તો બધાને
પછી પેલા અંદી નથી આવી
Vakishree VM Neve,
વકીલ છે બીએમ નેવે અભય પ્રતાપસિંહ ગગનદીપસિંહ વકીલ છે બીએમ નેવે એમની પાસે
નથી
11 12 બાકી છે સર. બાકી 13 આવી છે એક્ઝામ
7/24 માં
એ ઉપરના જે છે ને
એના એ જ છે
એ બીજું સપ્લિમેન્ટરી
7/24
4/24 માં જે 4 છે ને
લાલ અભય પ્રતાપ
સર એ 4/24 માં જે 4 હાજરી એટલે એક્ઝામ્પશન નહીં કરે ને એ જ છે એમાં એક્ઝામ્પશન આપું છું
બધાના
હા સર
તમે ચારે એક્ઝામ્પશન
હા સર બંનેની એક્ઝામ્શન આપો છો
કિશન અને ભાઈ
હા
પછી આ દશરથસિંહ ને બધા કુલવિંદર સ્કોર
સર ગગનદીપ ઉપર જે છે ને 12 નંબર એ આમાં 3 નંબર છે 4/24 માં જે 12 નંબર છે એ આમાં 3 નંબર કુલવિંદર 13 નંબર છે 4 નંબર
એ આવે છે
એક્ઝામ્શન છે બધાને ચારે ને
ગગનદીપ નું એક્ઝામ્પશન
બધા ચારે ને એક જ.
ઉપર બી એવું જ છે બધાનું
હા સર
એના
યસ
ચાર પ્રોવિન્શિયલ છે એ પંજાબનું ચાર્જશીટ છે ત્યાંથી કેસ એમનું એનઆઈએ ચાર્જશીટ ફાઇલ કરી સ્ટાર્ટ કરો
એમની કાપડ
યસ
સર સિવિલ
સાહેબ કોઈ આવ્યું છે
સાહેબ લખાય
સર એક 52/21 માં છે 3/21 માં છે ને 251/22 છે 3 માં છે
એ નંબર ની છે ને બધી હા એ લાવવાના છે ને
હા સર
હા એક સાહેબ છે
એક સાહેબ છે
યસ
સર સિવિલ
આવું डायरेक्शन वाली 5 थी।
अच्छा तो फिर फाइलिंग ये वाला
तो सिविल में 200
બાકી છે એમ કે પરમાર સર ફેક્ટ પુરાવા શરૂ કરવા છે. 1 નંબર છે પુરાવા શરૂ કરવા, 2 નંબર પુરાવા શરૂ કરવા છે, 3 નંબર ઇશ્યુ માટે છે.
इशू केम करना था?
હા, જવાબ રજૂ નથી, આરત થયેલી છે ફેટલ છે. 718/24 છે ક્રોસ માટે છે. એ કાં કાપવાની અરજી પણ પેન્ડિંગ છે ને ડેટ ડિક્લેરેશન. 5 નંબર છે એ પણ ડેટ એટલે એ ક્રોસ માટે છે. 6 નંબર છે સર તપાસ રજૂ છે એમાં પણ ક્રોસ માટે છે. વકીલ શ્રી એમ કે મકવાણા
718 में क्रॉस पे कर
હા સર ક્રોસ માટે.
चारे में क्रॉस मत
હા, ત્રણેયમાં ક્રોસ માટે. 85/24 છે હિયરિંગ માટે છે. વાંધાને અગાઉ રજૂ કરેલા આયા નથી.
पंचायती 24 में
હિયરિંગ માટે
कितने वाले क्लियर होती
ના સર નથી આવ્યા. ક્રોસ માટે છે.
જે છે ને જે સત્તાવાસી દુઃખની હવે એ ત્યારે છે ને મેન્ટલી ડિસેબલ જેવું થઈ ગયું છે, દાખલ કર્યા છે.
સિરિયલ નંબર 4.
તો હવે સત્તાવાસી સાહેબ હું એક નંબરની આપી દઉં કે એની
अल्फाबेन
એમની બેન એવું થઈ ગયું તો હવે અલ્પાબેન ની આપી દો.
ओके
કારણ કે એ જુબાની આપી શકે એવી પોઝિશન નથી.
तो बे जना છે ને
3 છે બાજી 3 છે.
3 છે.
હા, 3 બેનો છે.
તો રજૂ કરી દેજો બીજા તો નામ.
હા, રજૂ કરી દઉં ને એમના હાજરે કે તો નાજુક પ્રોટ લઈ દે એ એમસી
આયા છે
किसी
બોલાઈ ગયું.
नो किसी को का
સિવિલમાં કોઈ નામ છે મેન્શન કરવાનું સિવિલમાં.
ફરિયાદ લેનાર કોઈ કયા છે?
હા સર કર્યું.
પંચી છે ને
3/21 માં છે ફરિયાદ લેવી.
અને 4 માં પંચ છે.
4 માં પંચ ઓ પંચ
એક તપાસ થઈ ગયા છે.
હા એક તપાસ.
ચાલુ ચાલુ કરો.
52
be taken place because your honor kindly appreciate your honor exhibit 4 application for getting the certified copies of the documents
તમારે તમારે આપના ઇનિશિયલ શું છે?
Rajesh M. Chakwawal
5308
property with all DP Pandya sir
yes Mr. R.A.
RM
RMP Chakwawala yes
kindly sir go through combination what has happened your honor. So what has happened, Your Honor? The documents not provided by the prosecution, Your Honor.
yes
Therefore, that application exhibit 4 was given, Your Honor, way back in the 3rd month of this 2025, Your Honor.
બોલો PSL ને પોકાતા
It was pending, Your Honor. And thereafter the hearing was taken place
yes
and it was kept for order on the 18/6/2025.
documents were not for prosecution
Yes, Your Honor.
yes
So that exhibit, that is exhibit 4, Your Honor.
in application exhibit 4
Exhibit 4. And order was kept on 18/6, Your Honor.
or
18/6/24.
order on 18/6
Yes, Your Honor. So prior to that, the matter was listed on 18/6, Your Honor.
yes
Even though, sir,
yes
the learned officer, presiding officer has passed an order below exhibit 9 on 17/6. Antedate, Your Honor.
order below exhibit 9
9. It is a subsequent application, subsequent order, subsequent exhibit, Your Honor.
it will pass on 17/6
17/6.
yes
And the signature of the accused person were taken by the presiding officer on 18th, as if it is taken on 17th. Kindly appreciate your matter was not listed on 17th. So kindly see that page, my compilation may be looked into, Your Honor.
Yes.
Thereafter, we have to challenge that framing of charge before the Honorable High Court around consensus, Your Honor. Because it looks dirty, Your what I humbly submit before this Honorable Court, Your Honor.
Yes.
The matter was not on 17th.
Yes.
Though each and every page of the charge frame, Your Honor, page 35 of my compilation, please, Your Honor.
Your order dated 17/6/25
Yes, Your Honor. Kindly see, sir.
was challenged before High Court.
High Court ultimately, it was set aside by the Honorable High Court on consensus because everybody conceded that the matter was not on 17th, Your Honor. Kindly appreciate. It looks bad so far as Your Honor, bench and bar is concerned, Your Honor.
Came to be allowed.
Sir, kindly appreciate what I humbly submit before this Honorable Court, sir.
Yes.
Sir, kindly, my compilation, page 35, may please
Yes.
peruse for a plain reading, Your Honor.
Yes.
The page 1, duly signed by the presiding officer.
Yes.
Each and every page is signed along with date 17/6 on which the matter was not listed at all. Thereafter on page 2 of that charge frame, Your Honor, 17 with signature. Thereafter on page 3 of that 37, Your Honor,
Yes.
the presiding officer has signed along with the date, Your Honor.
Yes.
So it creates some doubt in the mind of the litigant, Your Honor, because, sir, the complainant is a lawyer, practicing lawyer, and he is being given audience during the trial by this presiding officer. What I humbly submit before this Honorable Court. For last 5 adjournments, he is addressing the court like anything. In the eyes of law, he cannot be permitted in a trial, Your Honor. What I humbly submit, it can influence the trial, Your Honor. He is a lawyer, practicing lawyer, Your Honor. We have objected. Even though, sir, presiding officer is inviting audience of this lawyer who is a complainant, Your Honor.
Yes.
It's an interference in the fair trial, Your Honor. What I would like to humbly submit, I am supported by the canon of judgments of our Honorable Supreme Court as well as the High Court that the direct audience or active role cannot be attributed to the complainant side, Your Honor. A private person cannot be permitted to address the court,
Yes.
even during the time of framing of charge also, Your Honor. Kindly appreciate, Your Honor.
Yes.
Even the prosecution has not opened his case for prosecution.
Yes.
By its own, the Honorable Presiding Officer has framed the charge, Your Honor.
Yes.
Therefore, we are compelled to go before the Honorable High Court. We have produced, Your Honor, the copy of petition.
Yes.
The grounds are mentioned, detailed grounds are there. Ultimately, sir, the High Court, sir, has set aside the framing of charge of this presiding officer.
Yes.
Thereafter, what has happened, Your Honor? Kindly see, sir, we have given an application, the adjournment application, exhibit 18, sir.
Yes.
18. Page number 71 of my compilation, Your Honor. Please.
Yes.
Sir.
69.
Right. Sir, kindly see, sir.
Yes.
It's a personal ground of a lawyer.
Yes.
Sir, on 18th, this application is preferred by the lawyer of the accused, Your Honor. Kindly permit me to read, Your Honor. Please, Your Honor.
Yes.
Application seeking adjournment. It is humbly submitted that the accused has preferred an application dated 19/3/2025 under section 230 of જેમાં exhibit 4 વાળી અરજી કરી છે, sir,
Yes.
which was placed for hearing on 2/6/2025. This Honorable Court on 2/6/2025 had conducted an exhaustive hearing upon the said application preferred by the accused and had placed the matter for orders for today.
Yes.
That is on 18th, Your Honor. Nowhere it is listed on 17th. Kindly appreciate, Your Honor.
Yes.
The accused submits that the advocate for the accused is on legs before the High Court of Gujarat. The quorum is mentioned, Your Honor. Quorum, Honorable Justice Divyesh Joshi, for matter listed at serial number 30 in the daily board. Kindly appreciate. It's a personal ground of a lawyer who is not able to present before this Honorable Court, particularly when he is before the Honorable High Court, Your Honor. Kindly appreciate, Your Honor. The advocate for the accused has been asked to continue his arguments post recess session as well by the Honorable High Court. It was not possible for advocate to come before this Honorable Court on that very day. In light of the same, the advocate of the accused is not in knowledge of order, because order was likely to be passed so far as Exhibit 4 is concerned, Your Honor, on that very day. If any, passed by this Honorable Court in furtherance of the application dated August 25, Exhibit 4, Your Honor. Thus, it is humbly prayed that this matter may be adjourned. So no heaven is going to be for what I humbly submit before this Honorable Court, sir. It's a personal ground of a lawyer. Lawyer is not afforded the opportunity, Your Honor. And sir, thus it is humbly prayed that this matter may be adjourned without passing of any adverse order, as the invaluable statutory rights of the accused pre-trial framing stage are intact. Because we cannot give our discharge application if the charges are framed, because documents have not been provided till date. Kindly appreciate, Your Honor. Prosecution has not opened his case even for the prosecution. Now, sir, let us read the order of the biased order, what I humbly submit before this Honorable Court. Read this application. Peruse the record. The matter is pending for framing of charge since law. The Honorable Supreme Court of India has passed an order. The Honorable Supreme Court of India has passed an order dated August 5, 2025 in SLP so and so in this matter for expeditiously trial. Sir, no order is passed by the Supreme Court. Absolutely erroneous observation. Erroneous interpretation is taken place by the learned presiding officer. What? Kindly permit me to read the order of Supreme Court, Your Honor. We have copy of it. Copy of it. Sorry. Sir, it was a bail application. Kindly appreciate. Trial is not expedited by the Supreme Court. Kindly permit me to read, sir, what Supreme Court has held in our bail application. May I read, sir? Please, Your Honor. Yes. We depose of this special leave petition by reserving liberty to the petitioner hearing to renew his application for bail after completion of 1 year. जो 1 year में trial पूरी ना था, तो I have been afforded an opportunity to renew my bail application before the trial court. Kindly appreciate, Your Honor. Now let us read. It is needless to observe that if an application is made before the concerned sessions court, the same shall be considered on its own merits, having regard to the progress in the trial. So on merit, as expeditiously as possible and in accordance with law. The suit is not, the trial is not expedited. What the observation of the Supreme Court, if I prefer an application, a renew bail application before the trial court, so that is to be decided as expeditiously as possible if trial is not concluded within 1 year. So that is not an endeavor on the part of the Supreme Court by this very order that the trial is expedited, Your Honor. Even though, sir, what learned presiding officer erroneously held in the application, Your Honor, Exhibit 18, sir. Kindly see, sir. Kindly permit me to read page 69 once again, Your Honor, of my compilation. The Honorable Supreme Court of India has passed an order dated August 25 in SLP criminal number 7637, which I read, Your Honor, in this matter for expeditious trial. No trial is expedited by the Supreme Court. Kindly appreciate, Your Honor. Today the matter is listed on what? On 18th की बात करें sir. The accused are in custody. It appeared that one advocate who is not on record of this case came with this application and to sign of the accused who is in custody. The advocate, the concerned advocate was before the Honorable High Court. The application was tendered by his colleague, Your Honor. Kindly appreciate, Your Honor. So that is the practice what I humbly submit before this Honorable Court. मैं number पण आप्यो साहेब. High Court ની matter નો number भी आप्यो કે post recess हमारे चलावવાની. Kindly appreciate, Your Honor. The documentary evidence list was produced on 2/6/25 and the prosecution has already opened his case. It is missing. Nothing on record. Prosecution has not opened the case, Your Honor. Kindly appreciate, documents are not provided to us. On the contrary, on the 18th itself, the documents were ordered to be provided in the court. absolutely erroneous finding. So the documentary evidence list was produced on page 25 and the prosecution has already opened his case. Hence, the matter is at the stage of framing of charge. The sufficient opportunity has not been given to us, Your Honor. Documents, even one of the documents is still remain to be given to us, Your Honor. Each and every document is required to be given. An order is passed to the effect, Your Honor. Kindly appreciate, Your Honor. And not only that, charge is framed antedate, Your Honor. And અમારા અસીલની સહી પણ સાહેબ એન્ટીડેટમાં લીધી સાહેબ. Kindly appreciate, Your Honor. So, there are 5, sir, of that application, sir. Hence, may I read, sir?
Yes, yes.
Hence, looking to the record and order of Honorable Supreme Court, the Supreme Court doesn't so say, Your Honor. Kindly appreciate, Your Honor. As the sufficient opportunity has been granted to the accused, no further adjournment can be granted for framing of charge.
Yes.
Hence, this adjournment application rejected.
Yes.
It's a prejudicial to the right of the accused, Your Honor. Kindly appreciate, Your Honor.
Yes.
Now, sir, let us read order below Exhibit 4, sir. Kindly appreciate on the very date the order was passed, Your Honor. Page 71, sir.
71.
Yes, Your Honor. The relevant, the conclusive part on page 73, sir. Detailed application was preferred by the accused, Your Honor. It's a valuable right to defend a case. We are having a right to even given the application the discharge, Your Honor. He has not followed the 226 and 27, Your Honor. CRPC, Your Honor. Sir, on page 73, sir, the investigating officer is hereby directed to produce before this court all the documents along with the list which are not relied upon and which are not made the part of the charge sheet. So some of the documents still remain to be given to the accused person. Even though the lawyer, the private complainant, Your Honor, who is a lawyer, practicing lawyer, is given audience by the Honorable Trial Court, Your Honor. Kindly appreciate, Your Honor. Now, sir, so we have to appreciate the matter, sir. Kindly appreciate, Your Honor. So far as the mind of the accused is concerned, Your Honor, because
Yes.
it creates a doubt, Your Honor. There is no reason. Kindly appreciate
Yes.
to sign the charge frame application for each and every date on prior date, anti-date, Your Honor. Sir, kindly appreciate. Now, sir, page 76 may kindly be looked at.
Sir, this application is allowed.
Sir,
Order below Exhibit 4, order.
allowed.
Application is
But
allowed.
documents have not been provided till date.
Only to assist your lordship, because I am the advocate on record before the trial.
Hmm.
May I just point out a little bit? એમાં શું થયું?
એમને અત્યારે આગળ કરો.
Right.
Okay.
Exhibit 4 ની
તમને
application
એમને
allowed.
કહેજો.
Okay.
તમને અત્યારે એમને તમે પ્રોક્સી આપી છે.
Right. Sure, I know.
એટલે તમે એમને તમારે કેવું હોય એમના મારફત કહેજો, તમને સાંભળશું. એટલે let him to complete.
Right.
Sir,
If you want to add something, I'll hear.
sir, I
you.
am obliged.
76.
Yes.
Sir, page 76, Your Honor.
Yes.
Kindly see
Yes.
the exhibit 10, sir.
76.
Page 76.
Yes.
Please, Lady Sahib Arabi. I'm
Yes.
Vipul Urfe Vicky, the applicant before this honorable court, sir.
Yes. Yes.
Now, sir, the sign is on 70 chalk. The case was not listed.
Mm.
Admittedly, sir. 70 chalk. હવે આરોપી જે બીજે દિવસ કોર્ટમાં આવ્યો સાહેબ 18 તારીખે એની સહી એન્ટીડેટમાં સાહેબ દીધી કોર્ટ. So that is not unheard of. That is something unheard of. What I humbly submit in absence of lawyer. Kindly appreciate. I was in the High Court. I have given an application for adjournment. My application was rejected. His signature was taken on that very day in my absence, Your Honor. Kindly appreciate. But the date is mentioned like it is to be presumed that the signature is obtained on 17/6, Your Honor. Kindly appreciate, Your Honor. It is nowhere mentioned
Yes.
in the plea.
We'll continue after this, sir.
Sir, I'm obliged, Your Honor. Really appreciate. There is no antecedent, Your Honor. Such type of application is given for the first in point of time. Kindly appreciate.
Yes.
The petty reason was there.
The antecedent aspect is not to be
I,
considered. while
I
taking
appreciate.
this
What I
up.
am humbly submit is not habitual offender.
Yes,
Or
yes.
first time is coming across such type of situation because there is a quarrel ban between the neighbors for a parking purpose. Reason was very petty. What I humbly submit, sir. Kindly appreciate, Your Honor. Now, sir,
You cannot
keeping
be-
this aspect in the mind, Your Honor, I am requesting the Honorable Court to go through page 81 of my compilation, Your Honor. Kindly see, sir.
Yes.
Page 81, the case status. Sir. On,
Yes.
sir, the date is PH, kindly got it, sir. Date said US है PH 25.
Yes.
Last but 3 in the middle.
Yes.
Opening up of case by prosecution. Case
Yes.
is not yet open throughout.
Yes.
It was kept on 18/25.
Yes.
Opening up of case by prosecution.
Yes. Yes.
So, sir, in this interstagnant period,
Yes.
kindly see, sir, order of exhibit 5, exhibit 4, Your Honor, has taken place on, sir, 18, sir. Sorry, sir. I'm sorry. 18.
Yes.
Order of exhibit 8 on 17.
Yes.
I'm sorry, sir. Order of exhibit 4
Yes.
on 18.
Yes.
Order of exhibit 8 adjournment application
Yes.
on 18.
Yes.
Order of exhibit 9,
Yes.
which is a subsequent in order,
Yes.
is passed on 17.
Yes.
First day before that. Exhibit 9. Order of 10, exhibit 10 is also on 17.
Yes.
Order of exhibit 11 is on 17.
Yes.
Order of exhibit 12 is on 17. Though it is titled as if the order is passed on 18. It is presumed. What I humbly submit before this honorable court,
Yes.
the accused were not present
Yes.
on 17th before the honorable court.
Yes.
Now, sir, even lawyer is not present on 17th.
Yes.
Lawyer is also not present on 18th, Your Honor. Kindly appreciate, Your Honor.
Yes.
Adjournment application was given.
Yes.
Not only that, sir, straight away on 9/7, the matter was kept for evidence.
Yes.
So during that period, sir, we challenged the order of framing of charge before the Honorable High Court.
Yes.
And High Court has passed, Your Honor, the order on 7/7.
Yes.
Now, sir, on 7/7, the para 6 of the order, I will request Your Honor to go through the para 6 of the order of the Honorable High Court, Your Honor.
Yes.
On page, sir,
Yes. 87.
87.
I'm sorry, Your Honor.
Yes.
87, sir, para 6.
Yes.
The High Court is ultimately on consensus. Sir,
Yes.
it is very important to note, Your Honor.
Yes.
Even the prosecution and the state has given no objection
Yes.
to setting aside the order of frame of charge, Your Honor.
Yes.
Kindly appreciate. So there is something fishy what I humbly submit before this honorable court, Your Honor.
Yes.
Now, sir, para 6 is very material. In view of the above, without assigning any further reason,
Yes.
in view of the consensus arrived at amongst the learned counsels for the parties, including sir prosecution, including sir private complainant, sir,
Yes.
his consent was also there before the Honorable High Court.
Yes.
That Sessions case number 126 of 2025 was never listed for hearing before the Sessions Court on 17/6/2025, and yet the order whereby the charges were framed bears the date 17. Not only the charges, plea was also recorded,
Yes.
which is contrary to the record, and as the parties have agreed, state order is quashed and set aside.
Yes.
The Sessions Court is directed to hear the parties in accordance with the order dated 18/25, which is that order, Your Honor, to submit all papers before the court and to supply the copies thereof to the accused side subsequent to that, Your Honor.
Yes.
So 18 order must have been that all papers are required to be submitted before the court by the prosecution agency. It was the order passed by the
Yes.
London Sessions Court, Your Honor.
Yes.
So, in accordance with the order dated 18/25, and in light of the decision of the Honorable Apex Court mentioned by the Sessions Court in its order dated 18/25, that is, in the case of P. Punnaswamy versus State of TN, so and so, after giving fair opportunity to the accused persons in accordance with law, the charge may be framed. Your Honor. Now, sir, straight away, now I'll take your honor, the matter was listed on 9/7. So kindly appreciate the order of Honorable High Court has passed on 7/7. Matter was already listed on 9/7, sir. Kindly appreciate your honor. On 9/7, some documents were produced. And more than 1,000 papers, your honor. It is a bulky record. Kindly see, sir. And thereafter, sir, the matter was kept on 15/7. And it was orally directed by the presiding officer, that you pass a procedure, the documents are received. Sir, some of the documents are still required to be received by the applicant accused, your honor. Kindly appreciate, your honor. Sir, it's a bulky record, 1,000 papers. Sir, fair opportunity. Sir, kindly appreciate, your honor. He has directly skipped, your honor, the presiding officer. Sir, kindly see 207, 226, 227, sir. We have a right to further investigation also after perusing the record, sir. Kindly appreciate, your honor. We have a right to give the discharge application prior to this, your honor. Even the case is not opened by the prosecution agency, your honor. So unnecessary hurriedness is adopted. Now, sir, what I am very submit, particularly when, sir, we have challenged the order.
Presently, matter is posted on which date?
21st, your honor.
It is for what?
It is for hearing of framing of charge.
Yes. Then what?
Sir, what I humbly submit, sir, bulky record is there. And we have certain doubts in our mind. Kindly appreciate, your honor. See, sir, 17 matter was not listed, sir. Something has happened. And kindly see, sir, we are supported by the judgment.
The fair trial ની વાત છે.
Eh?
એ fair trial 408 ના powers ની વાત નથી. તમે
હા, sir.
judgment જે rely કરો છો ને, that pertains to fair trial.
I appreciate, your honor.
It is not with regard to exercise of powers under section 408 of CRPC.
I appreciate, but what I humbly submit, sir,
Yes.
there is one bias. Sir, the Supreme Court judgment, your honor. Sir, para 2.2, your honor,
Yes.
page 3,
Yes.
2.1, sir.
Natural justice, fair trial, judgment
It is
only
the-
after due of the judicial process. Quantum of punishment, this proportionate to offence, whether conclusive evidence of bias. Yes.
We have to appreciate the matter from the angle of applicant. Kindly appreciate, your honor.
Ah,
We have a reasonable
Yes. Yes.
doubt in our mind. What I humbly submit before this honorable court, your honor. There is no harm, your honor, to provide us the proper opportunity or full complete time to go through the documents, your honor. We have to peruse the document. We have to read the document, your honor. We are having the scope of kindly see 207, 226, 227, your honor. Straight away, sir. Is upon that, your honor. Kindly appreciate, your honor. And now the matter is also posted on 21st for hearing of charge, your honor. So we have a sufficient reason, your honor. Kindly, a fair trial is required to be, a chances of fair trial is required to be given, your honor. Kindly appreciate, your honor. Not only that, sir, I am supported by the
227 no compliance also.
sir, meaning, sir, we have
227 compliance. તમે જે judgment બોલો છો એ.
S.H. Vora Sahib
હા.
judgment.
Yes.
A detail how 2262 પણ સાહેબ
Yes. Yes. એટલે
para 12, sir.
yes.
Para 12, sir. On plain reading of section 226 and section 227 of the CRPC. Got it, sir?
Yes.
Makes it clear that Sessions Court has to begin with opening of case by the prosecution. Sir, yet
Yes.
case is not open throughout, your honor. And then followed by arguments on behalf of the prosecution accused,
Yes.
culminating in passing order provided under section 227 or 228 of the CRPC. either to discharge or to pass order of framing of charge.
Yes.
Chapter so and so consists of section 225 to 237 of the CRPC, providing relevant provisions regarding trial before the Sessions Court. Section 227 relates to discharge and section 228 relates to framing of charge.
Hmm.
Sir, valuable rights. Kindly appreciate. We have to go through the bulky record, sir. We have to
This
meet the client. Kindly appreciate.
bulky record contention is to be raised before the court concern, where the court concern would be hearing you for the framing of charge. 408 bulky record,
Sir,
those submissions are not available, Mr. Counsel. Bulky record is not relevant for this application to be decided.
sir, the
It's-
client has
Material,
lost his
that
faith, Your
that
Honor.
you can raise, yes.
Kindly appreciate, Your
Yes.
Honor.
That is the prime
Client
contention.
has lost his faith and trust in the court, Your Honor. Kindly appreciate straight away, Your Honor.
That is your prime contention.
Yes.
Yes.
Sir, looking to the list, the events,
Yes.
client is having a certain doubts in its mind. You're not only that, sir. The complainant is a lawyer, practicing lawyer, sir. He is taking a ride in the court, Your Honor, and the court is permitting him, Your Honor. Sir, I'm also requesting the honorable court to even go through the CCTV footage of the court premises, Your Honor. Sir, what I humbly submit, there is a doubt in the mind of the litigant, Your Honor. Sir, it's a first case ever in the life. We are not habitual offender.
Yes,
Sir, very pretty reason. પાર્કિંગ નો પડોશી વચ્ચેનો ઝઘડો એમાં કોઈ બી બનાવ બન્યો છે કોઈ કારણસર અલ્ટિમેટલી ઇટ વોઝ ફર્સ્ટ સર 323 જતી સાહેબ પછી ભાઈ કન્વર્ટ થઈ
Subsequently, it has resulted in murder.
યસ what I am believe sir કોઈ એવી કોઈ કોન્સ્પિરસી કે એવો કોઈ cold blooded કોઈ વાત નથી પણ what I humbly submit when sir as a principal court
Yes.
the litigant has come, citizen has come to this honorable court
Yes.
by reasonable apprehension, Your Honor,
Yes.
that he is not going to afford the fair and reasonable chance or a fair trial or unprejudiced order or whatsoever it may be, Your Honor. So that is to be kept in mind. And we are having the other judges also, Your Honor. Balance fee is required to be taken by this honorable.
Yes.
અમે સાહેબ કોઈ અમારો કોઈ ઈગો હર્ટ થવા માટે અમે આયા નથી. Kindly see, sir, see,
ego ની વાત જ નથી.
sir,
There is
what,
no question of ego.
what I humbly submit,
One
sir,
can't have any ego.
sir, kindly see.
Yes.
Okay, framing of charge normally no one would challenge before the High Court. Kindly appreciate, Your Honor.
Yes. Yes.
હવે અમે સાહેબ ચેલેન્જ કર્યું
Yes.
consensus the order passed so
Yes,
admittedly sir
It is
something
possible.
wrong has been done, Your Honor. Kindly our sir presiding officer sir is the authorized the dignitary, Your Honor. Sir કોઈ vindictiveness અમને એવું એપ્લિકેશન થાય છે સાહેબ કે ભાઈ તમે અપીલ કરી અથવા તો આ ચાર્જ ફ્રેમ કુમાર જે એમની વિરુદ્ધ જે એલિગેશન અમે નાના મોટા કર્યા સાહેબ હાઈકોર્ટમાં સર કાઇન્ડલી સી અમારું એંગલ બી જુઓ સાહેબ અમે એવું નથી કહેતા કે કોઈ એક પર્ટિક્યુલર પ્રિસાઇડિંગ ઓફિસર પાસે કેસ મૂકો
Yes.
any judge befitting to this honorable court including even this honorable court sir we are prepared for a trial. We don't want to prolong the matter. Kindly
Yes.
appreciate, Your Honor.
Yes.
Sir, we are under trial prisoners, Your Honor. હવે સાહેબ અંડર ટ્રાયલ પ્રિઝનર જયારે આપના અંદર કોર્ટમાં આવે કે ભાઈ હું તો અંદર જેલમાં છું છતાં પણ હું મને આ સાહેબ જજ જોડે મને અનુકૂળ નથી આવતું તો મને એપ્રિહેન્શન રિઝનેબલ છે therefore sir kindly permit me to read the contents of my application, Your Honor, please, Your Honor.
Yes.
What I humbly plead in my application, sir, may be looked into, Your Honor.
Yes, it would be looked into.
And sir, hurriedly,
Yes.
and even the complainant was asked to remain present for examination by the court on the same day, sir. Kindly appreciate. 18 તારીખે સાહેબ 5 ઓર્ડર પાસ કર્યા
Yes.
અને 17 તારીખમાં નાખીને સર કાઇન્ડલી સી કે ભાઈ કારકુનની કોઈ ભૂલ હોય સાહેબ કે 17 તારીખ ટાઈપ કરવાની કોઈ મિસ્ટેક હોય સાહેબ સાહેબ આ કેસમાં જોઈએ સાહેબ તો નામદાર સાહેબે સાહેબ સહી સાથે દરેક પાના પર તારીખ લખી સાહેબ
Yes.
the day on which the matter was not listed. Kindly see, sir.
Yes.
So I am requesting, Your Honor, kindly appreciate, Your Honor, the request of the applicant, Your Honor,
Mm.
and a fair chance Principle of natural justice, Your Honor. He's apprehending some, because vindictiveness is, sir, kindly see, the mindset is a natural process. What I humbly submit, sir. When we have challenged the order stating before the Honorable High Court that the matter was not listed on 17th and backdated order has been passed even on plea of charge, Your Honor. Kindly see, there is a direct allegation against the court concern, Your Honor. Kindly appreciate. The main point is this, Your Honor. So it's a natural action and reaction in the mind of the presiding officer. So that would create, sir, prejudice. Kindly appreciate, Your Honor. That would create a little bit, if little bit prejudice is there, Your Honor. A fair concept of fair trial will be vitiated, Your Honor. Kindly appreciate, Your Honor. There are all possibilities, all probabilities, because it's a natural phenomena. Kindly appreciate. It's a nature of a human being. Ultimately, we all are human beings, Your Honor. Kindly appreciate. So we have, sir, kindly see, sir, in petition before the High Court, we have made certain pleadings against the concerned officer of the court, Your Honor. Kindly appreciate, Your Honor. That is a part and parcel of the record. So if directly or indirectly there is any possibility, if a remote possibility is there, because we have come with some substance before this court, Your Honor. And that substance, according to me, very serious in nature. Might be not serious in nature of any other person, Your Honor. Kindly appreciate, Your Honor. The person who is not present before the court, the sign has been taken place in backdated, Your Honor. On the one and the same, with signature 1717. So kindly see, we have to appreciate the matter from that angle also, Your Honor. And sir, we are praying, Your Honor. So we have lost faith in the officer, Your Honor. So there are 6, Your Honor. That it is further submitted that there are, in my application, Your Honor, that it is further submitted that there are more than 1,000 papers tendered by the prosecution in the last week in bits and pieces, and even some accused are not given those papers and video footage properly, and the said facts itself suggest that due compliance of section 207 of the code has not taken place, and in absence of such compliance, the matter should not have been proceeded with framing of charge or should not proceed any further. That such a kind of lapse on procedure would completely vitiate the trial and would be a ministerial, and even otherwise the applicant has lost trust and confidence, and therefore the present application, Your Honor. Thereafter, sir, para 7, sir, my application, Your Honor, that the present applicant accused has highest regard for the court of the law, and the present application is also filed reading Article 21 of the Constitution of India, which requires a fair trial and unbiased adjudication of the matter. The present application is completely bona fide and without any malice, and is filed in the best interest of justice. And sir, it's a first case ever in my life, Your Honor. Kindly. It's a question of my life and liberty. I don't want to take any chance. Kindly appreciate, Your Honor. And looking to the events taken place, some exchange of word would have been taken place, Your Honor, in the court hours during the court period, Your Honor. Sir, why I'm putting a question to myself? Why the framing of charge is backdated or antedated, Your Honor? So that creates some doubt in the mind of the litigant. Kindly appreciate, we have to appreciate the matter from that angle also, Your Honor. I am supported by documents, Your Honor. I have come with the document. There was no listing of this matter on 17th. Kindly appreciate, Your Honor. So, furthermore, Your Honor, I have prayed, Your Honor, in para 8, Your Honor, that the applicant further submits that from the overall facts and circumstances as envisaged from the record of the case, and considering the conduct of informant, advocate as well as the concerned court, the applicant feels that the trial of the sessions case would not be culminated in a fair and unbiased manner, and there will be a greater chance to travesty of justice if the opportunity of fair trial is not provided to the accused. These are the allegations we are with limitation, Your Honor.
Yes.
When we are saying something, sir, when a citizen is having an audacity even, sir, to come before the High Court as well as this honorable court, Your Honor, So at least the reason is that should be required to be kept in mind.
Yes.
It's a natural phenomena, Your Honor.
Yes.
A bias would take place, Your Honor, and injustice would done to the present applicant. Therefore, this application. આનાથી સાહેબ મને કોઈ ફાયદો નથી. Any judge,
Yes.
any presiding officer, and furthermore, it is submitted that this honorable court, principal judge of the City Sessions Court, has power to exercise the jurisdiction mentioned in the provision either on his own or on an application made by the interested party with a view to meet with end of justice and equity, and therefore also the present application. સર અમારી પહેલી જ જીવનનો કેસ અને આવી પહેલી જ અરજી અને આ તો પહેલી વખત હાઈકોર્ટમાં ગયા સાહેબ અમે.
Yes.
So that the applicant has shown the entire facts and circumstances of the case as mentioned herein above, and therefore the applicant placed herein as under, be pleased to allow the present application, be pleased to transfer the sessions case number so and so from 37th Court of Learned Sessions Court, City Civil Court, so and so, to any other learned court of the City Sessions Court.
Yes.
That is my humble request.
Yes.
And no harm is going to cause to anybody, including state, Your Honor. Kindly appreciate, Your Honor. If a reasonable doubt is there in the mind of the litigant, Your Honor,
Yes.
following the events. So at least I am a citizen, Your Honor. Kindly appreciate, Your Honor.
Citizen to
Fair trial.
citizen, each and after the citizen.
Sir, basically he's conducting the matter.
Yes, yes.
I am the newcomer in the matter, so
Yeah.
Your Honor can provide him some assistance here.
એને શું હશે ને? તમે
ના
આટલું
સાહેબ,
કહી
એટલે
દીધું.
એક જ aspect છે.
આટલી પહેલા વાંચી દીધા 3, 4, 3, 6, 7, 8.
સાહેબ અમુક વસ્તુ બોલવા જઈએ ને સાહેબ
Yes.
તો અમને ખબર પડે સાહેબ કે ભાઈ
Yes.
કઈ બી બોલાય કઈ આગા પાછા શબ્દો થાય તો સાહેબ અમારે પછી
Yes.
we are having certain limitations, Your Honor.
I'm only going to state what is in my personal knowledge. What had happened is, I have been the advocate on record from the trial court till the Supreme Court for this application. My lord, on 7th, when the matter was conducted,
Yes.
a detailed inquiry was embarked upon by the High Court, and the
Yeah.
state was called upon to put it in affidavit.
Yes.
Subsequently, the High Court went
Yes.
and convinced the state that
Yeah.
you give consensus in this, or else I will have to go to an extent that I wish not to. Not to. And my lords, the High Court's order do satisfy our entire grievance. The High Court has taken care that now the matter is back to the stage of 207. The para 6 of the High Court order clearly states that matter is back to stage of 207. Sahib, when the matter was listed on 15,
Yes.
when the matter was listed on 15, our humble request, Lordship, this was our humble request before the court,
Yes.
that there is a reason that the presiding officer had passed a categorical order to provide us the papers not relied upon by the proceeding.
Yes.
એનું મૂળ કારણ એવું હતું સાહેબ કે ચાર્જશીટ અગર 300 પાનાની હોય
Yes.
અને ઇન્વેસ્ટિગેશનના બાકીના પાના જે અમને પ્રોવાઈડ કરવામાં આવે 1200 પાના છે.
Yes.
So therefore, we were on the court categorically observed that they may be provided documents not relied upon. એ અમને પ્રોવાઈડ કરવામાં આવ્યા સાહેબ 9/7. હવે 1200 પાના હું 5 દિવસમાં વાંચી લઉં, મારા ક્લાયન્ટને કન્સલ્ટ કરી લઉં, that is impossible.
Yes.
Therefore, we went to the presiding officer on the 15th that
Yes.
your lordship, the clock has been turned back. It is at 207. Let us peruse the document. The court categorically directed and said to me
Yes.
that you immediately furnish a purchase, that
Yes.
you have gotten all records. I said, my lord, I have to compare 300 pages of charge sheet with 1200 pages. I have to see what new statements have been provided, and I have to see whether the people who have preferred affidavit before this honorable court that their statement has been recorded, એ લોકોના statement આયા છે કે નહીં?
Yes.
Prima facie it appears there is no. Secondly, I convinced the court that the basis of passing of an order by the High Court of quashing the charge is to make sure that my pre-charge remedies remain intact. તો સાહેબ મને એવું કીધું કે 3 વાગે ચાર્જ માટે હિયરિંગ થશે, તમારે જે કરવું.
Yes.
એટલે 3 વાગે મેં કીધું સાહેબ prima facie before going or embarking upon any of my remedies, I want to state on record that 226 has not been complied. The court said immediately to the prosecution, you comply right now, orally. Now, my lord, if it would have been that easy, then Ashok Bhai Chowatiya would not have been passed. Manisha Goswami would not have been passed. Mohammed Major would not have been passed. These three major landmark laws on 226 would not have been passed. અને મારું મૂળ આર્ગ્યુમેન્ટ એવો હતો કે સાહેબ જ્યાં સુધી એ લોકો મને પ્રપોઝ ચાર્જ ના આપે and they do not state how they want to proceed with the prosecution, how would I know what am I supposed to be discharged from? અને assuming that I want to file a discharge application, હું નથી કરતો, ચલો એક સેકન્ડ માટે, but looking at the extra record that I have gotten, is there not a chance given to me for 173A? Is there not a chance given to me under section 91 to satisfy the court desirability and necessity of a document that is still withheld? Sir, તમે એક વારમાં ચાર્જ કરશો તો everything gets vitiated and suffocated. I will go. Yet the court said now, on the next date of hearing, I won't consider any application. I will only hear on 228. My lords, the principles of hearing on 228 are vastly different from 227, 173, and 91. How can I embark upon 228 hearing, your lordship? Because if 226 is not complied with, I am not given chance under 227. Why am I pushed? Why am I constrained and suffocated to argue on 228? And this is the only adjournment application I have given. And my lords, I have categorically argued on 15 that your lordship, CRPC ma 24 section 24 is the only provision that grants the authority to the complainant to remain present. 24A, that he can be of the assistance of the prosecution. સાહેબ અમે જ્યારે એડજમેન્ટ એપ્લિકેશન રજૂ કરીએ છીએ, અમે જ્યારે પુરશીશ રજૂ કરીએ છીએ પ્રોસિજરલ કમ્પ્લાયન્સ નું, અમે જ્યારે કોઈ પણ ટાઈપની રેમેડી ઇન્વોક કરવાની એપ્લિકેશન આપીએ છીએ, it is the complainant who opposes and not the state. I am covered by the direct judgment, yet it was not taken consideration of, and it was orally said that I would not go into those matters. I will only hear on framing. Therefore, my lords, I understand that what is falling from my lords is that I have to convince your lordships on 408 of CRP. But my humble request is that it might be an apprehension, but it is a reasonable apprehension on our mind that if we may be provided, as the Supreme Court says, your lordship, as to test of the likelihood of bias, what is relevant is reasonableness of the apprehension in that regard, in the mind of the party and not of the judge. The proper approach for the judge is not to look at his own mind and ask himself, however honestly, am I biased? But to look at the mind of the party before him. So it is to be seen if I'm fighting with a sword in an open air. હવામાં તલવાર ફેરવતો તો સાહેબ, I understand that there are several things where people use as dilatory text. And the accused number 1 has never furnished an adjournment application except on 18th. The record is very clear. We have never ever dilated the trial. We have never postponed the trial. But my lords, I cannot be pressurized to furnish a push. Every time I go before the court, my invocation of remedy ek sangharsh na hovo જોઈએ સાહેબ. And each time I argue, your lordship, that there is some compliance that is yet to be done, your lordship. There might be something that is for me.
Honor.
Your honor. Your honor.
Lordship નહીં.
And your honor, હજી એક વસ્તુ એ છે,
Yes.
સુપ્રીમ કોર્ટ નો ઓર્ડર જોશો ને, ત્યાં હું એડવોકેટ ઓન રેકોર્ડ છું, ત્યાં પણ આ આર્ગ્યુ થયું.
I'm not saying that you are not the advocate on.
ના હું સાહેબ એટલે હું જે પર્સનલ નોલેજ માં કહું છું, બીકોઝ સર અમારો what we are embarking
is not expedited.
Yes.
એટલે what we are embarking upon, જો સાહેબ એમાં એવું છે કે આ
આમ તો સાહેબ બધા આ બધી કેસ જલ્દી ચલાવવા જોઈએ, no doubt about it, but it is not a direction in the by the Supreme Court.
But even Honorable High Court has said for expeditious disposal.
but that is in light of the
Supreme Court judgment.
18-6.
Supreme Court નું judgment.
મને વાંધો નથી સાહેબ, એ લોકો ફાસ્ટ ચલકે.
હાઈકોર્ટે બી સુપ્રીમ કોર્ટ ની જ વાત કરી છે. સુપ્રીમ કોર્ટે તો સાહેબ બેલ માટે અમને જલ્દી ચલાવવાનું. At least we have to interpret. Sir, we are also the court officer. What I humbly submit, at least there might be some misunderstanding. What I humbly submit, sir, kindly appreciate. It is not a direct order of the Honorable High Court to expedite.
The trial is not proceeded further. then within 1 year you can file application.
સાહેબ
that was the endeavor on the part of the
You
Supreme.
can
હશે
seek-
શું?
you can
તો
seek
બધા
revival.
હશે શું સાહેબ?
Revival.
અમે અંડરટેકિંગ આપવાથી અમે કોઈ મુદત નહીં માંગીએ છીએ.
Yes.
નવી કોર્ટ કોઈ બી
Yes.
ઇવન તમે તો કહેતો તો આ કોર્ટમાં પણ અમે તો જઈશું અમે તોય મુદત નહીં માંગીએ અમે નવી કોર્ટમાં બી કોઈ મુદત નહીં માંગીએ સાહેબ અને હવે શું એક વખત મુદત માંગી નથી સાહેબ કાઇન્ડલી એપ્રિશિએટ
Yes.
એટલે વી આર નોટ પ્રોલોંગિંગ ધ મેટર કાઇન્ડલી તો
અને
તો હવે
Supreme Court માં એવું હતું
further-
સાહેબ કે we were on the biasness of investigation. The court said that at the bail stage I won't consider.
Yes.
You proceed the entire procedure before the lower court. I will make sure that you have a limitation of 1 year and those applications that you prefer. Because we were of a view, my lords, if my lords are giving a liberty of 1 year and if I
Yes.
proceed for an unbiased investigation procedure before the lower court,
Yes.
it is but natural that that liberty would be exercised કારણ કે આ બધી procedure પૂરી કરતા જ 1 વર્ષ થશે.
Yes.
And therefore, the Supreme Court said that I will expeditiously ask the Sessions Court to consider your application.
Yes. તમારો initial શું છે?
TP Pandya.
he is advocate on record.
Yes. Devers Pandya.
Devers.
Yes.
I am Rajesh Chakwa.
Yes. RM.
RM. Rajesh Chakwa.
ચકવાલન સ્પેલિંગ શું છે?
CHAK WA
AK.
CHAK WA ફરી બે વખત WA અને LA.
ચકવાવાલા.
ચકવાવાલા.
જતા રહે કે શું?
No, it's like-
હા, બેઠા. Right.
અમે સાહેબ ક્લેસમાં ના ઉતરીએ સાહેબ પ્લીઝ મને એવું થાય સાહેબ પણ
No, I'm not saying that you have entered into any class.
બસ.
Yes, Mr.
મેટરના જે
Like, even otherwise, this is between the applicant and court only. If he would have released that. This is application number 408. Whether I need to exercise the powers or not. That would be decided by me only. પણ તમારે કઈ કેવું હોય તો એમાં આર્ગ્યુમેન્ટ કરી છે પછી એવું ના થાય તમને દલીલ કરવાની તક ના આપી. યસ એનું પ્રાઇમ કન્ડિશન છે બાયસ શું છે કે સમ બાયસ એમ why then post
ખાલી એપ્લિકેશન
Irritated order.
બાયસ હોય એવું
અને their contention is that some
સંઘાણી સાહેબ પણ
Backdateમાં હોય.
sequences and events has taken place which has led the accused that there is some bias which has led the reasonable apprehension as per Mr. Devesh Pandya.
જી સાહેબ.
આ પેલા અહીંયા
Apprehension reasonable.
I think
Yes, 20